Hello, everyone, and welcome to another live session with immigrationquestion.com. In these sessions, we cover important topics for immigrants, both documented and undocumented, focusing on legal status in the United States. Our goal is to answer as many of your questions as possible. I'm Nikita, and I'll be your host for today. So take a moment to picture this. You're a parent balancing work, school drop offs, and community events. Everything feels like it's going as planned until one day a letter arrives. It's a notice to appear in immigration court. Suddenly, your future feels uncertain, and all the stability that you've built is at risk. For many, this is when fear kicks in, but it's also when hope steps in. This is where cancellation of removal comes in, a chance to protect your family, your life, and your dreams in the United States. Today, we're talking about Cancellation of Removal Explained, a second chance for LPRs and non LPRs, where we'll walk you through how it works and how it could help you. With me today is an esteemed immigration attorney with extensive experience in advocacy and community engagement. She is an active member of the American Immigration Lawyers Association and has contributed to multiple committees. She's passionate about helping individuals and families navigate the immigration process and combines her legal expertise with a heartfelt dedication to making a difference. Please join me in welcoming attorney Alicia Morgan. We're so excited to have you with us today.
Thank you so much for inviting me. It's my pleasure to be here.
Thank you. To everyone watching, get ready for an exciting session. Grab your notepads and pens and let's dive in. Attorney Morgan will walk us through Cancellation of Removal Explained, a second chance for LPR and non LPRs.
So, the first thing to know is that cancellation of removal, although it is sometimes daunting to think about being in immigration court, it's a way that a person can get a green card through being in immigration court. Now, what is cancellation of removal? So we're going to talk about today a couple of topics about cancellation of removal. We're going to go over what it is. We're going to discuss what's the different kinds of cancellation of removal. So there's cancellation of removal for non-permanent residents. There's a different cancellation of removal if you're a permanent resident. And then there's also a cancellation of removal available for VAWA applicants or people who have been abused. So the first thing is cancellation of removal. It's a deportation defense that is going to allow you to get a green card in immigration court, or if you're a resident, keep your green card. So there's actually different standards that are going to take effect if you're a resident, if you're undocumented, or if you have suffered abuse. And another thing to take into account is, like many different types of immigration relief, Congress has set a limit on how many cancellation of removal cases that judges can give out every year. And that number is 4,000 cases. So it's not really that many. If you think about it, another case that has an annual cap, for example, is the U visa. And that one has a $10,000 person cap. So it's really not very many to only give out 4,000 for the whole country in 1 year. So what it is that whenever the cases get to 3,500, the judge's assistants start sending out letters to the judges so that they know they need to reserve decisions, as in don't make a decision yet on the cases that go after that 3,500 case for that year. But let's get into it. Cancellation of removal for non-permanent residents. These are people who don't have any immigration status and they got put into removal proceedings. You need to have at least 10 years of continuous physical presence inside the United States, although there is an exception if you were in the active military for 2 years. If you were in the active military for 2 years, all you have to show is 2 years continuous presence, not the 10. Another thing you have to show for those 10 years is good moral character. So that means in general that you've been a good person, right? That you haven't committed certain crimes that disqualify you. And another thing that the government considers a requirement, even though it's not specifically in the law, it's something that the judges expect to see, is 10 years of taxes. That's part of what the government expects to see to be considered 10 years of good moral character. It's also going to help you for the physical presence documentation. Another thing you have to show is that you have exceptional and extremely unusual hardship to a qualifying family member. And that's actually a very high level to show. And if you think about it this way, most of the cases that you have to show, and I'll show you the next slide when we get to for people who are residents already, they only need to show extreme hardship. And also VAWA applicants or those who qualify as abused people who have been here inside the United States and they qualify for the VAWA cancellation, they only need to show extreme hardship. But people who are non-permanent residents and don't qualify for the VAWA part of the law, they need to show exceptional and extremely unusual hardship, which the government has decided that that's basically something that goes beyond just being separated from your family members. Extremely unusual, right? So there's a couple of examples that the government has given us. So mainly like a severe mental illness that would prevent that they're not able to get help to treat in the person's country. Someone who's going to face significant persecution, for example, somebody who's been maybe they're LGBTQ and in their country they could be killed for their beliefs, right? Things like that have been considered to be extremely unusual hardship, goes beyond just extreme hardship, right? So which are the family relationships that are going to qualify? It has to be a U.S. citizen or lawful permanent resident, parent, child, or spouse. So a child means under 21. So the problem with some of these cases is that they could take up to 10 or even 15 years in some cases to resolve. I know that sounds like a long time, but I had a case, for example, that we started in 2015 and it's still not done. Okay, so some of these immigration cases can really drag out, and a child that started out as 10 or 15 years old could end up aging out if there is not a resolution in your case within, say, 10 years, right? So that's something to take into account. And if you have an immigration lawyer and you're getting close to when your child might turn 21, you should ask your lawyer to file what's called a motion to advance so that you can try to push your court hearing through faster, right? The child has to be unmarried as well. So tell your child, do not get married, please, because we need your case. Don't get married yet, right? What kind of evidence is going to help somebody qualify for cancellation of removal for non-permanent residents? So in general, you have to have those 10 years. We did mention that you can document that with taxes, which is part of what the government also wants to see for your good moral character. Taxes, you can backdate those taxes. You can go to the IRS, go to a tax specialist and let them know what you were earning, even if you didn't get a W-2, even if you were getting paid under the table. You can estimate what you earned for those years. You are most likely going to have to pay money back to the government, but they can put you on a payment plan. Okay, so you can file taxes late, and you can get an ITIN number to file those taxes if you were, for some reason, weren't filing the taxes because you didn't have a social security number, which a lot of people who are filing for cancellation never did officially receive, right? Unless you had some exception, most people didn't have a work permit. So if you didn't, you can file for an ITIN number with the IRS, and they can help you get that number. And after you have that number, you can file those 10 years of taxes. Another thing to get would be rent receipts. If you had social media, you can go to that. But I know a lot of people, the problem is a lot of people are trying to lay low and be under the radar when they're out of status. But it's exactly those documents that would show that you're here that you need for this sort of a case. So you can get records of your children. For example, if you have US citizen children and they were in school and you're listed as the parent on their records, you can get your children's medical and school records. That's going to help you if you can't find your own rent or work records. You can also go to your employers and ask if they could write you a letter in the event that they did not have you officially on the payroll and don't have pay stubs to show that. And you can also get your bank records. That's a great idea to show the 10 years physical presence, because most people do have a bank or a credit card or something, and that will show you where that you were inside the United States, you were going to Publix, you were going to Target here inside the US, and that will go a long way in showing that you meet those 10 years. The next thing you want to show is good moral character. If you've had any arrest, even if they were misdemeanors, even if the case was dismissed, you need all of those criminal records. So that's going to be the documents about arrest, as well as that you finished and completed the case. You can get those directly from the court. That's usually the best way to do it. But you could also get the police reports from the police stations themselves if the court doesn't have those documents for any reason. So your lawyer can usually help you and give you advice on where to get the records. And you can also get, if you don't, there are some people that don't have the exact recollection of when they were arrested. Start out with getting an FBI fingerprint test. So if you get the fingerprints done, and now they have places that can get them done in a couple of days. We have one in Miami that can get you the results in like 2 days. It's great. So if you can get your fingerprints, then you'll have a long list, hopefully a short list of the times you were arrested. And there you can get the record much easier because you'll have the data on what were the arrests. The next thing you're going to want to show about the good moral character is letters from family and friends that can say that you're a good person. If you ever done any volunteer work, if you ever, if you go to church, if you're a member of a faith community, get the pastor, get someone from your faith community to write you a letter to say the ways that you've been helping the community. If you help out at your children's school, get the PTA or someone from the school to explain in the ways that you've been helping with your children's school. Okay, you can get your boss to write you letters, as well as family and friends. After that, we're going to want to show the exceptional and extremely unusual hardship to your qualifying family member. This is huge to deciding if you're going to win or don't win the case. Now, I know this is hard, but you need to talk to your family members about how possible it is that you could be deported. Why? Because if you don't talk to them like, hey, mommy and daddy, mommy could be deported from the United States, you won't get a reaction from them. They haven't been separated from you yet, right? And you actually need proof of what would happen if you were separated. We hope that you're not actually separated from them. In order to get this evidence, you need to get your family members treated for any conditions that they have or could potentially have. Sometimes maybe your child is having trouble at school and the teacher is saying they're not paying attention, but you haven't taken them to a doctor to find out what is the real issue. Maybe they have autism, maybe they have ADHD, but you're not treating them. Maybe you personally don't like medicine. Forget about your personal release for this moment, because you need to get evidence about your children and your parents and your husband, your spouse, their conditions that they have, as well as the conditions that you could have, because that can also go into the discretion. These cases are so discretionary. The judge can say yes or the judge can say no based on how they feel about your case, in addition to whether or not you meet these qualifications. Okay, so it's very important to get everything tested out. You also need to get your qualifying family members, to the extent that you have children that are old enough to do this, or your spouse or parent, take them to an immigration psychologist. We have a great list of people that are in the Miami area, but we can also help you find a psychologist, an immigration psychologist in another state if you're located somewhere else. But it's very important that they do an analysis on how your family member would suffer without you, because sometimes it's not just physical problem that your family member would have. Maybe they suffer from psychological problems, emotional problems. Maybe they have anxiety or depression, but they're not taking medication for that. That needs to be documented, and an immigration psychologist can really help in making the proof that you need to win this case. So the next case that we want to talk about is cancellation of removal for residents. So this one is a little easier to prove because they only need to show 7 years physical presence. And that starts from the moment they came inside the United States. They didn't need to already have the green card yet. Even if they were on student status, maybe they came in on a tourist visa and they overstayed, it doesn't matter. Whenever they started living inside the United States is going to start the 7 years physical presence. And there's something to take into account. There's something called the stop time rule. Basically, if a person commits a crime that is going to disqualify them, or it makes them basically a deportable case for someone who's a resident, that crime can stop the time on their 7 years. The same applies to the 10 years for the cancellation of removal for non-permanent residents. But what's very important to note is that you don't even have to have been convicted for the crime. So you really need to talk to an immigration attorney about even things that you have committed that you weren't exactly convicted for, even times that they arrested you, but you were the case was dismissed, could be used against you to stop time for the 7 years. So make sure you talk to your immigration attorney about that, because that's just a point on what could disqualify you from this sort of relief. So you need to have 5 years with a green card, 7 years physical presence, and then not be convicted of an aggravated felony. Okay. And so that would basically mean certain types of felonies that you have a year punishment is a possibility that they could have given you. And your immigration attorney can help you know which of the crimes could disqualify you. Okay. And then the next thing is they have to show extreme hardship to a family member, to a qualifying family member, which is going to be that child, parent, or spouse. Okay. What evidence to include for a resident? It's going to be similar evidence, right? But you only need to show extreme hardship. So extreme hardship can be, it's a lower standard. This is the standard that they use for many waiver cases, such as an I-601 or an I-601A. And in these kind of cases, you need to show extreme hardship, but it doesn't need to be at the level that is extremely unusual above a standard separation from your spouse, child, or parent. So, for example, being forced to leave a stable job and community, and being forced to return to a place where you have limited opportunities economically, separation from a spouse who will have trouble making their finances met, maybe some difficulty in the new country due to your parents, your child, or your spouse not speaking the language. All of those things can be taken into account. In addition to, the government is supposed to make a cumulative analysis about your extreme hardship. It doesn't need to be that one specific factor is extreme. They can take everything into account. The next one I want to talk to you guys about is actually less known about. It's called the VAWA cancellation of removal. And this form of relief is actually great because a lot of people who aren't quite aware can qualify for this. It's a person who has at least 3 years physical presence inside the United States. But one thing's great to know is that the stop time rule does not apply to these cases. So that means that even if you had come in, say 2 years ago, and then you got the notice to appear in court, which usually that stops your time, you can still go on and continue to accrue the 3 years before your lawyer files the cancellation of removal for VAWA for you. And the time that you file the NTA does not stop your time. Another thing that's important and interesting is that even if you were to get deported from the United States or ordered deported because the judge actually found that you didn't qualify for anything, and then you accrued the 3 years, even after you got the order, and say you did an appeal with your attorney, then you could still do a motion to reopen and say that now I qualify for cancellation or removal because I have those 3 years physical presence. So this is amazing, to be honest, because this rule is much more generous to the applicants. So the person had to have been subject to extreme cruelty, which is part of the VAWA statute, but it says has been subject. So even if your spouse, child, parent was cruel to you in the past, but now you guys have repaired your relationship, there's no requirement that you would have had to have left the relationship, or that you separated from them, or that the abuse is ongoing. So the abuse could have been in the past. It could have been a rebellious teenager who was abusive to you, and later they got over the hormones or whatever it was, and now they're kind to you again. You can still qualify for VAWA cancellation if you had been subject to extreme cruelty. Okay, so the extreme hardship, you have to show extreme hardship, so the lower standard than what they do for regular cancellation of removal, non-permanent residents. So just extreme hardship, the same level that they show for lawful permanent residents. This hardship can be to even yourself, to the applicant themselves, to a child or a parent. And this is interesting because, like I said, this is not like a standard application for relief. This is a little bit more generous than most. You can even include children or parents or family members who do not have status. So it can be to yourself. The hardship can be to yourself, to your family who don't even have status, right? So this is really very generous. One thing that I did want to mention is that there are no derivative children included in the VAWA cancellation of removal. So if you did want to do a VAWA cancellation of removal, that you qualify for it, talk to your lawyer about the idea of filing a VAWA with the I-360 form directly with USCIS, because that application, you can include derivatives. And as soon as you had the receipt notice for that, to give yourself a second bite at the apple, you can also file an adjustment of status before the judge with the proof that you filed the I-360. And then you'll have the adjustment case pending before the judge. But the I-360 case does have to be decided first before they can move on with that application. Unless you were an arriving alien. There are some exceptions that everything can be filed with USCIS. So what to expect at an individual hearing for cancellation of removal. So like I said, these cases can drag on for 10 to 12 to 15 years. We don't know if there will be any changes that the Trump administration may make to the process. Maybe they'll speed things up. I'm not sure. Right now, the courts are overwhelmed. So for that reason, I expect that it's going to continue to be at least 10 years that you may have this case ongoing, with the continuances that you need to do. If you filed a VAWA, for example, or any application before USCIS, that's going to have to be decided before they move to the next step. So there's a lot of delays that will happen inevitably in the case, and that can benefit you while you're waiting to see that you qualify for the relief that you need. But when you finally get to that last hearing, what's going to happen? So expect that the hearing will take minimum of 3 to 4 hours. And there are situations that you can get 2 or 3 or even 4 individual hearings. It really depends on your judge. I do have one case that we're on the 4th individual hearing, and the judge has still not made any decision on the case. So everything depends on your judge. Talk to your lawyer about this judge. Who do I have? What is their personality? What is likely to happen with the judge that I have? Because every judge is different. And the judges even post there. You can find this information online. Your lawyer can help you find it. What is the rate of approval that the specific judge that you have gives for cases like cancellation of removal? So another thing is that you can bring witnesses who can speak on your behalf to this hearing. And your lawyer needs to know at least typically a month, at minimum a month before you have that final hearing, who is going to be at your hearing to speak on your behalf. And your lawyer is going to need to prepare each of those witnesses. Who you want to bring is not just everybody who likes you or your friends or your pastor. No, you want to bring people who have specific stories that they can tell about your good moral character and about your hardship that they know your family will suffer without you. Okay, so it's better to bring 2 or 3 really good witnesses than to bring 10 or 15 people who think you're a nice person. Okay, because if anything, that's just going to delay everything, and they don't have that much to add. Instead, get letters from all of those 10 to 15 people who like you, but bring 2 or 3 key witnesses to your hearing. Ideally family members, but it can also be a neighbor or a friend or someone from church who you really impacted in your life. Another thing to take into account is that the hearing, your lawyer is going to ask you questions first, and this will happen the same for your witnesses. First, your lawyer will ask your questions, They're going to set up the scene. They're going to tell a story. They're going to paint a story with words about your case. Then the government attorney gets a turn. Okay. And what they're trying to do is trip you up. They're trying to catch you in a lie. They're trying to paint you as a bad person. They're going to try to bring up something maybe from when you were detained, or something in your history, your criminal history. Maybe even you didn't get convicted. But keep in mind that you do need to be prepared. The government attorney is not your friend, and they might be a jerk. They might be very mean. So your lawyer can help prepare you to how to react. One thing you want to keep in mind to do that's going to help you is to always review everything that's on your application, anything that was submitted to the court, all of your criminal arrests, if you have any. You need to review all of those documents, because the government attorney or your lawyer is going to ask you questions about that information. The judge can also ask questions about that information. One important tip is to always look at the person who's asking the questions, not your interpreter. If you don't speak English as fluently, you're going to have an interpreter there. But even though the interpreter is the one who's answering your questions, don't look at the interpreter. Look at the person who's asking the questions. Okay. And the second tip I want to give about that is to only ask the question that you were being asked. So it's sometimes people want to give more information, or you want to take the time to explain yourself about the question that's being asked, but that will only infuriate the judge or the trial attorney who is working for the government. You need to only answer the question that they've asked. If they have additional questions, which they definitely will, they're going to ask follow-up questions. Okay. So to avoid the hearing taking way much, hours longer than it needs to, don't go rambling or adding information that wasn't asked. Stick to the question that was asked. When were you arrested? January 1st, 1993. Then you wait for them to ask the following question. Okay. So it's super important that you have a lawyer to represent you in these cases. But, there are people who can't afford a lawyer. If you don't have the money to afford a private lawyer who has good immigration reviews, I definitely recommend that you contact a nonprofit organization. There are nonprofit organizations that represent clients in immigration court. They don't take every single type of case. I know that some of the nonprofits here in Miami, for example, don't take people with certain criminal records. Okay. So if you do have a case that the nonprofit will not take, it's advised to, save up your money. Like I said, this is a case that can take 10 years. Most likely you can find a law firm who will work with you on a payment plan. Okay. But I definitely recommend to hire a lawyer, because the government attorney has a lawyer against you who's everything they're trying to do is deport you. So you should have a lawyer to defend you. Okay. These are laws that we're going against. Right? So they have laws that are going to come out while you're waiting that could change the landscape, and you want a lawyer on your side to argue those points for you. Okay. What about prosecutorial discretion? So under the Biden administration, we were closing cases left and right. We were getting cases administratively closed and cases dismissed. And that's because the Biden administration, as the Obama administration and other Democratic administrations in the past had done, they had a goal to close cases out of immigration court to make it more efficient. Not so under the Trump administration. He has just one of the, more than a dozen executive orders that he signed on his first day in office was to undo all that Biden had done for the prosecutorial discretion, meaning that now we're going back to what Trump had set up for his prosecutorial discretion in 2017, which was to say that there is no priority for deportation. Everyone should be deported. So instead of focusing efforts and priority on deportation of people who have severe criminal records, people who are a danger to society and the public, people who have been terrorists, people who are recent entries, all of the Biden administration goals and priorities on who should be deported first, where should that money that the government has for deportation, where should it be focused? Now it's all gone. Everybody should be deported. So what that means is that it's going to be much harder to try to close any court case. So if you have a request to administratively close or dismiss your case with your lawyer now, we've seen it happen in our side that the trial attorneys are telling us that the cases are denied. We have other people that are just saying, well, things have changed, so we just understand that those cases are no longer going to be approved. I can tell you an example about a case that I had that was a very strong case to get the case terminated under Trump's first administration. It was a guy who had temporary protected status and had had it for since 2010, but he had been put in proceedings, and his wife was bipolar and schizophrenic, which means that she was on a lot of medication and she relied on him for everything. He was taking her to make sure that she took her medication. He was helping her if she had, an event and she needed to be hospitalized. He was helping her in every way. She would need to go to the psych ward sometimes, and he would be there as her support and he would visit her. Anyway, we did all of the documentation to show, and he was a perfect case to get the case closed out of court. And in a moment in the Biden administration, once they took back over, that case was approved. But under Trump, they wouldn't even consider it. We tried twice and they said, don't even ask. So that's to take into account. The people who have a case administratively closed, that means your case is suspended. It does not mean your case is done. Those cases might be reopened. They might be put back on the calendar. There was also something under the Biden administration called the No Court, I can't remember the name of it, off docket initiative. So that initiative was to take a lot of cases that were not priorities for deportation off of the active court calendar, and these are people who have the case still pending, but they don't have a court scheduled. Those people may get scheduled soon. Okay, so we don't know exactly what's going to happen, but we do know that closing cases is not a thing right now. Another thing is that it's recently come out that among the hidden in some of the language for these executive orders that came out the other day on the 20th of January is that there's going to be changes to who qualifies for a work permit if they have a case pending, but they don't have anything approved. So that would affect people, for example, who have a U visa pending, who have even a green card case pending, but they haven't yet won the case. It's going to make a lot of hardship for a lot of people. There's also supposed to be a registry for all non-citizens. Now, this sounds, to be honest, like World War II crazy, but I just read about that today, that it's inside of one of these memos that says it's going to require all non-citizens to register and present their fingerprints to the U.S. government under a rarely used provision in U.S. law. So it's going to say that the people who didn't register have now committed a crime. Now, I haven't seen how they're going to implement this, but it is something that I read about just today that it's inside of one of these agreements. Another thing is that they're expanding the use of expedited removal to a wider use than has ever been used in history. So previously, the most expansive use of expedited removal, which is a deportation without a hearing, meaning that you don't need a hearing, you don't need to see a judge. The government has the right to put you on a plane and deport you right away, would be for people who are within 100 miles of a border and had been here less than 2 years. So previously, it was required for you to meet both of those standards, both of those prongs. But now it's going to be that anywhere inside the United States, if you have been here less than 2 years, or you don't have the proof that you have been here more than 2 years, that the government could deport you without a hearing. So this is very dangerous. It's a much more expansive interpretation of expedited removal. So everyone who doesn't have papers should definitely bring proof that they've been here a minimum of 2 years. Just keep it in your car. Here I am in front of Disney, with my kids 2 years ago. Here's the birth certificate of my child who's 3. You need to keep that record with you at all times because it's dangerous. People could be deported even erroneously without getting a hearing. Okay, so we went over a lot of information now. This is what I had about my presentation. I do want to share my phone number to anyone who wants to take it down. But if you don't get a chance to take it down, you can definitely contact Immigration Questions because they'll also have my contact information. But I'd like to answer any questions that anyone has now about cancellation of removal or any other questions that you have.
Okay, thank you so much for that, Attorney Morgan. That was really insightful. Welcome to our audience if you're just joining us, and we're thrilled to have attorney Alicia Morgan with us today, a respected immigration expert who's contributed greatly to today's topic. This is immigrationquestions.com, a platform that makes immigration easier. Ask your questions in any language and get connected with a verified attorney who can provide legal guidance. You may even get a free confidential consultation. Just visit www.immigrationquestion.com and sign up today. Attorney Morgan, before we get into the live Q&A, as someone who helps immigrants every day, what are your thoughts on immigrationquestion.com and how it supports the immigrant community?
I think it's great. So a lot of immigrants don't know where to turn on where is information that is trustworthy. There's a lot of people who write blogs, but you don't really know those people. So it's great to have a source that you can go where there are reliable experts regularly contributing. So I commend you on your website. It's great.
Thank you, Attorney Morgan. So this has been a great conversation. Now it's time for questions and answers. Drop your questions in the chat and we'll answer as many as we can. Or if you'd like to ask live, you can call us on 516-703-3483. And we have a question from Salma. Salma's been living in America for more than 10 years, but she doesn't have a legal status. She asks, how can I prove I meet the residency requirements for cancellation of removal?
So the first thing to note is that not anyone can file for cancellation of removal. You need to be in front of an immigration judge, meaning you need to have received a document called a notice to appear. That is the charging document that the government sends to say that they want to see you in immigration court. So it's not that anyone can just file for cancellation of removal. But if you're in front of the immigration judge, what you can show to say, I've been here for these 10 years, is going to be documents that you've been for bank accounts. You can use taxes. Even if you haven't done all of your taxes, go and back. You can do the taxes after the fact with a CPA and use an ITIN number. You can get receipts for places you have lived. You can use Airbnb. You can use, if you have an Amazon account, go into that because I'm sure you have records of having things delivered to places inside the United States. That's a good idea. And bank records are perfect because that's going to show where you've been purchasing things, including your Uber Eats.
Thank you, Attorney Morgan. We have another question from Maria. What will happen to my case now if the judge deny my cancellation of removal request? Will I appeal?
So if you have been denied for cancellation of removal, I definitely recommend that you appeal because doing an appeal is going to buy you time. I would say even if you're not sure that you want to appeal because of the cost or any other reason, you should consider definitely telling your lawyer that you'd like to reserve appeal because it will give you an automatic stay of deportation for 30 days. And it doesn't hurt to get that, even if you have plans to consider leaving the United States, you have that extra 30 days at the least. But appealing is a good idea because it takes typically minimum of 3 years for a decision on those cases, and that's going to buy you time. And if you find a good lawyer who can help you, then they may find something that is a grounds for appeal. Oftentimes, either the judge or the trial attorney has made some error in your case. And if you had a good lawyer who was objecting whenever there was something that was going awry at the time of the court, then what you need to do is have your lawyer get a copy of the DAR or the FOIA for the entire immigration case with the EOIR. And there they can review the transcript to see if they find any errors in the case that would qualify you for an appeal.
Okay, Maria, I hope that answers your question. We have another one from Gideon. Can I include my children in my application for cancellation of removal?
So, cancellation of removal, I believe it's just for the applicant. I need to check that out. I think that you can have children, but I'm not sure. Derivatives included. No, unfortunately. Well, wait a minute. You cannot for the VAWA. No. Only the person who has the cancellation of removal case is going to get the green card. So sometimes there's cases that you have that you may have joined. So if you have like a family that is all in deportation defense, you're going to each need to present your own defense. And there's some cases that have derivative like asylum, and there you can ask them to consolidate it under one application. But for cancellation of removal, each person needs to qualify separately.
Okay. Now we have another one from Abrahima. What will happen if I apply for cancellation of removal, but another immigration law come out while I wait?
So if while you're filed or you've already filed the application for the defense that you believe you qualify, and then something else comes up that you might qualify for, there's nothing that prohibits you from filing for everything that you qualify for. So maybe they come up with another temporary protective status, or who knows if Trump's going to do something nice for the people, the dreamers, or anything like that. But if there's something that comes out in the law that you qualify for, you can always file it the moment that you qualify for it. In some cases, can stop your deportation. They may qualify you to get your case out of deportation court. Like I said, under the Trump administration, it's much harder to do that. But file everything that you qualify for until you have a green card in your hand. If you're a victim of a crime and now you qualify for the U visa, try that as well. Do anything that you seem to qualify for, even if you've already filed for cancellation.
Thank you for that, Sunny Morgan. We have another one from Yusuf. How long can I stay in the United States if my cancellation of removal case is still pending?
You can stay as long as the case is pending. So that will put you in status, if you want to say it that way. While your immigration case is pending, you're here and the government needs you to stay here to complete that immigration case. If you do leave the United States while the case is still pending, you will be executing your deportation, because people who are in removal proceedings don't have permission to leave the United States. So if you do decide to leave because your grandma is sick, well, you've deported yourself. So you should stay until the case is decided.
Okay, Yusuf, I hope that answers your question. So I think that is a wrap. That's all the questions we have time for today. Thank you so much for joining us, and a special thank you to our guest speaker for sharing her time and expertise. We hope today's session on cancellation of removal and the chance for non LPRs and LPRs was helpful. Visit immigrationquestion.com to connect with an experienced attorney who can guide you through your immigration journey. If you missed anything or want to rewatch, check out the recording on Spotify by searching Borderless Talk by immigrationquestion.com. Join us next week for another great session on employment based immigration. Once again, thank you so much, Alicia, for having spent time with us today, presenting to us today, and we can't wait to have you back.
It was truly my pleasure.
Have a wonderful afternoon and see you next week. Stay informed and empowered on